Good evening and welcome to the June 2015 Richardson Law Office's Legal Hangout. Today we're going to talk about creditor harassment. Now, people that are in financial difficulty and have a large amount of debt that has become unmanageable end up dealing with debt collectors. People calling or writing, trying to collect a debt for their clients. This can be very stressful. It can cause a lot of problems. It can even break up marriages. And this is a real problem, obviously. But what I want to talk about today are ways in which you can deal with it and to educate you as to a federal law that protects you from creditor harassment or debt harassment by debt creditors, more specifically. And if you know your rights, you know that you actually have remedies against those debt collectors for violating this act. It's what's called a strict liability act. In other words, you do this, you do something you're not supposed to, you get in trouble, you can end up having to pay damages. Now, sometimes the harassment can lead to actual damages, perhaps a loss of a job, and then lost wages become the actual damages in the lawsuit. Or if not actual damages, you can receive statutory damages. In other words, the actual act says how much money you can make when the debt collector violates the act. The statutory damages are up to $1,000. And you can also get attorney's fees, so it doesn't cost you to have an attorney fight for you and enforce this act against harassing debt collectors. Now, this act was originally enacted back in 1978. It's been around a long time. And I started practicing law back in late 1985, and I started working for a collection law firm. So this is something we knew about and had to be trained in, because in 1986 it became applicable to lawyers. So not just debt collectors, but law firms representing creditors and trying to collect the debt on their behalf are also subject to these regulations. You might have heard when they call or you call them, whether it's a debt collector or a law firm, you'll hear this office is attempting to collect a debt, and the information obtained will may be used for that purpose. That's a standard mantra that must be used in all communication with a debtor by a debt collector, and that's why you're hearing that. Now, this law came out of a lot of abuses and problems that existed back in the 60s and 70s as debt collectors became more and more creative in ways to harass you and try and get your money. Back to just pranks that we would pull as kids, ordering pizzas delivered to somebody's house back in the days before caller ID, and you can actually get away with that. Debt collectors would do that. I've heard stories from guys that were in the industry, were debt collectors before the act that was in place, ordering pizzas delivered to a debtor's house, ordering flowers delivered, and of course COD, as a way of harassing them and getting them to pay, squeaking the wheel even louder. So when faced with a huge outcry nationally, Congress in 1978 enacted something called the Fair Debt Collection Practices Act. And this act has a lot of teeth and can protect you and be your shield against creditors. And today what I wanted to do is start to give you some idea of what these debt collectors can and can't do so that you can look after your rights. And if you identify some violations of this act by debt collectors, then you know you might have a cause of action and you need to talk to a lawyer. Now, I have some things I want to talk about today. I'm probably not going to get to all of them. It may spill over until next month's legal hangout in July, which is going to be on July 23rd at 5 p.m. So let's get right into it. and I'll tell you a little bit about what these guys can and can't do. One of the biggest things that they can't do is misrepresent things, lie to you, trick you, try to fear you or scare you into paying the debt. And they can't make any kind of misrepresentation, any kind of fraudulent misrepresentation, where they know or should have known what the actual story is, but they misrepresent it to you in an effort to get you to pay. This can be a big thing. If you don't pay, you're going to be put in jail. And in New Jersey, and speaking from the context of New Jersey, as I'm a New Jersey attorney, there's no debtor's prison. You can't go to jail because you didn't pay a debt. But they'd like you to think that, because that scares you into action, that scares you into paying. So that's a big misrepresentation. Some smaller representation by a debt collector, even a law firm where there's no lawsuit, in written communications that say XYZ creditor versus John Doe in the header of the letter that you receive. That implies that there's litigation going on, that they're suing you. And if they're not suing you at the time, just putting that in the letter can be a fraudulent misrepresentation, a violation of the Fair Debt Collection Practices Act. And as I said, it is a strict liability act, law. So you violate it, you're in trouble. So something as simple as that. So they can't misrepresent facts, and that's often how they get into trouble. But let me give you a rundown of some of the things that they can't do. Number one, they can't call you at inconvenient times. They can't ordinarily, and the default is that absent some information that they have from you on what an inconvenient time is, they can't call you before 8 o'clock in the morning or after 9 o'clock at night. If they do that, they're violating the act. Simple as that. Okay. Your phone provider may give you the ability to log incoming calls. You may have proved that they called you before 8 a.m. or after 9 p.m. Now, let's suppose you work a night shift. Let's say, for example, you're a nurse at a hospital ER, and you're working the graveyard shift, and you work from 12 midnight till 8 a.m., assuming it's an 8-hour shift. A lot of nurses I know work 12-hour shifts, but just for the sake of argument. So a swing shift or a graveyard shift. So your day, your regular day, is going to be sort of the flip of what most people's day is. So calling between 8 a.m. and 9 p.m. when you're working the night shift, and maybe you come home, and you're at 9 a.m., you're asleep. You come home from work, you're exhausted, you go to sleep, and they're calling you. And you call them and say, hey, look, I work nights. This is when I sleep. Don't call me after this time or before this time. And once they're on notice of that, if they start calling you during that inconvenient time, then they're violating the act, because that is an inconvenient time for you, and they've been placed on notice. So they can't harass you by calling you that way. Next, they can't call you if you told them you have an attorney. Say, look, I've hired an attorney to deal with my debt. Talk to him or her. You don't talk to me. Here's his name. Here's his phone number. That happens a lot in my bankruptcy practice. In fact, it's a general rule. Once clients retain me, I say, if a creditor calls you, tell you you're represented by an attorney to prepare a bankruptcy petition, they are not to call you. You give them my name and telephone number, and they are to call me. All right, so any future attempt to contact them. Now, any kind of contact, any kind of communication, whether it is a letter, an email, a phone call, if you've told them you're represented by an attorney and given them the contact information for your attorney, they should not be contacting you. They should be contacting your attorney. So that's another form of harassment. They can't do that. Now, if they call you at work, and you say, hey, look, I can't take personal calls, all right? I can't take personal calls. I can get in trouble here at my job. Stop calling me here. I mentioned earlier about actual damages for a violation. You lose your job. Let's say creditors continue to call you at your job, and as a result, and way after you told them that you can't accept personal calls, you get fired. And you're told it's because you're constantly getting calls from debt collectors. This is not allowed. You keep getting these calls, we're firing you. So you can go after them and say, hey, you may have a lost wages claim. So they can't contact you if you've been advised. They contact you at work if they've been advised that you cannot accept calls or take personal calls at work. So that's another thing. Now, if you just don't want them to call you anymore, say, look, I don't want you to call me. I don't want you to write me letters. I'm not going to pay. All right? Or I can't. I'm either disputing this debt. I don't know this debt. Go away. I never, for whatever reason, you don't honestly believe you owe the debt, and you tell them to stop contacting you. Stop calling me. Stop emailing me. Stop sending me letters. Stop. All right? Now, you have to do it in writing. Send them a letter. And once they receive it, they have to stop contacting you. All right. Now, it's not from the date you mailed it. It's from the date they received it. I would assume at least 3 business days from the date you mailed it to give them an opportunity to receive it. You might even want to send it by certified mail so you have a green receipt card so you know exactly when they did receive it. That would be even better. So if they start calling you or contacting you after they got the letter and you have the green receipt card to show when they got it, then they're in trouble. They violated it. Now, there are some exceptions. They can contact you again just to say, okay, we got your letter, we're not going to contact you anymore. Or to say, all right, we got your letter, we're not going to contact you anymore, but because you won't talk to us, we're going to throw this into suit. Now, assuming that they really are going to do that. They can't misrepresent facts. All right. But they can call you to do that. And then there are certain communications in the course of litigation that aren't considered communications. But basically, the constant phone calls, things like that, they have to stop once you've sent them that letter. So one way to protect yourself from that is to send them a certified letter telling them to stop calling you. Now, that just stops the phone calls and the communication, or it should. That doesn't solve the problem for you. You still have that debt out there that you've got to deal with. So you either have to negotiate some sort of deal with them that you can afford, assuming you're in a position to do that, or talk to a bankruptcy attorney about filing bankruptcy, but you have to do something. Because ultimately, that debt collector, chances are that if the amount of money is large enough to make it worthwhile, will send it on to an attorney to institute suit. And then you do have a whole other problem. They can't communicate with third parties. Now remember, the whole idea was to intimidate you, to embarrass you, was to do things that will get you to pay, to squeak the wheel. The debt collectors used to call your neighbors. All right, there would be phone directories that you could get that would show phone numbers from a geographic standpoint, where they could figure out the phone numbers of your neighbors in a cross directory. Call your neighbors and say, hey, will you tell your neighbor Joe Smith to pay his bill? He owes us $3,000 and he hasn't paid us. You can't do that. You can't discuss the debt with a third party like that. Now, if they're trying to find you, say, look, we're trying to reach Mr. So-and-so about a personal matter. And we need to get in touch. Do you have a phone number for them? Or an address where we can send them a letter? If they're just doing investigation for contact information, that's an exception. And they can also usually talk to a spouse about the debt. Not children in the house, but a spouse. So that they really can't communicate with third parties. If they do that, they're also a violation of the Act. Threaten violence to you, your property, or to your reputation. Now, I haven't heard about this happening a lot, where people are threatening to have you beaten or to destroy property, but threats to reputation, again, threats to say, hey, if someone should happen to find out you owe all this money, attempts to embarrass, again, squeaking the wheel. You can't do that. Use obscene or profane language on the phone. Same thing. I haven't heard of this happening a lot, but it used to happen, as I say, in the old days. But they can't do that. They can't use obscene or offensive language with you, again, in an attempt to harass you or motivate you to pay the bill. They can't call you repeatedly. Now, they can, once they call you, you answer the phone and you talk to them. All right. It can be for 30 seconds, but they've reached you, they've talked to you. They cannot call you again that same day. Repeated calls, again, it can't be to talk to you. You've already talked to them. Now, a lot of this is common sense. It's ways of identifying behaviors and tactics by debt collectors which are not reasonably designed to simply collect the debt. I mean, clearly they're doing it for the purposes of harassment. You know, telling your neighbors about the debt. They're trying to embarrass you. They're trying to get you to pay. Harassment by damaging your reputation, talking to your neighbors, embarrassment. Use of foul language. So clearly, if they've talked to you that day, there's no good reason for them to call you again that day. They've already spoken to you. So clearly, the only reason they could have, reasonably speaking, for calling you again that day is to harass you, so they can't do that. Now, when they call you, they have to identify themselves properly. They have to say, you know, this is the ABC Debt Recovery Company, and we're calling you with regard to your Citibank account, just to pick a creditor. And we're calling to see if we can resolve this balance, affect some payment, et cetera, et cetera. So they have to identify who they are. And if you ask them where they are, you say, okay, whereabouts is that? What is your address? I'd like to send you a letter. Okay, and you can use that information if you wish to send them a certified letter to tell them to stop contacting you. But they have to give you that information. They have to identify themselves. They can't hide behind just they can't hide. They have to say who they are. And a lot of times you'll hear that, and we've heard it a lot when we call, you know, this call may be recorded for quality assurance purposes. Well, that may be part of, for an ethical debt collector, they may be recording the calls that are reviewed periodically to make sure that their employees are continuing to be in compliance with the Fair Debt Collection Practices Act. But because not all states allow them to record without telling you they're recording, what are called two-party notice states, then they have to tell you that. For example, in New Jersey, as long as one of the parties to the conversation knows it's being recorded, you can record it and use it. So if they're recording and later you sue saying they said something wrong, well, hey, I want to hear those recordings. Produce those recordings. So if they say something about a recorded line, make note of that, because you may need to listen to it later. The only other thing I wanted to leave you with before we finish up for this month is one of the biggest scare tactics they'll do is they'll try and create a sense of immediacy with you, that something dire is going to happen if you don't pay. If we don't receive the money by Thursday, we're going to attach your wages. Now, what they don't tell you and what they leave out is that if you don't pay by Thursday, then we're going to send it to an attorney who's going to open a file, who's then going to file a complaint, who's then going to serve it to you, who's then going to enter a judgment, and who is then going to attach your wages, which could be months down the line. Right? They don't tell you that because they don't want you to know that. They leave out. That's a sin of omission. That's fraud by omission, misrepresentation by omission. They want you to know that that's something that's going to happen immediately. Now, they could say, if you don't pay by Thursday, we're going to send it to a lawyer and they're going to sue you. Well, they can say that as long as they actually intend to do that. If this is, say, a $300 or $400 debt, and there's no way they're going to send it to a lawyer. They're just trying to collect it themselves. If they say they're going to do that, that if you don't pay by Thursday, they're going to refer it to a law firm, well, then that's a misrepresentation of fact. That's, again, trying to squeak the wheel, trying to get you into action. So that's enough for today's episode. But if what I've told you today sparks some interest, says, hey, wait a minute, I got a call from a debt collector and they did this, and you're wondering whether that's a violation of the Act, or they did one of the things I talked about. Leave a comment below this video. You can tweet a comment or question to @SJRLaw, or you can send me an email at steve@richardsonlawoffices.com with a question or comment, and I can talk about it next month. I'm going to get into some other stuff with the Act and ways for you to protect yourself and maybe reach out to an attorney. But think about what we've talked about, and if you're watching and you are having financial difficulties and you're getting these calls from debt collectors and you have a question, they're saying or they're doing this, is this kosher? Leave a comment below, tweet it, email it to me. I'd be happy to discuss it at next month's Hangout. So if you like this Hangout, click the thumbs up button below. Even better, if you want to continue to watch these Hangouts and other instructional and informative and educational videos I post regularly to this channel, hit the subscribe button. And there'll be a regular feed of information on various topics from my practice that you can watch. But continue to tune in. As I said, it's every month on the 4th Thursday at 5 p.m. I'm going to be on vacation on the 4th Thursday of this month. That's why this month's early. But next month is going to be July 23rd at 5 p.m. So I'll see you then. In the meantime, enjoy your summer, enjoy your 4th of July holiday. I'll see you next month.